trial where new and compelling evidence emerges after the appeal process has been exhausted. The petition also rests upon the assertion that the petitioner's rights to a fair trial and due process have been compromised. And the petitioner's plea is that the proceedings, conviction and sentence in Thika criminal case number 5165 of 2007, Nairobi High Court criminal appeal case number 371 of 2008, and Nairobi Court of Appeal criminal case number 376 of 2011 be set aside and quashed, and the petitioner be afforded a new trial. The petitioner claims he has been in custody since November 27th of November 2007, and thus urges this court to allow the petition so that justice can be seen to have been done. In particular, the petitioner alleging that the complainant in the case before the Thika court has now sworn evidence stating that she was forced by her grandmother and the officer commanding police station at Ruto to give false evidence against him, threatening to shoot her, and he wishes the trial court to consider this evidence. Mary Jenny testified at her oath that she fabricated the allegations against her father due to threats from her grandmother Rose Wanjiku and a police officer by the name Adhiambo. She explained that at the time she was threatened with harm if she refused to testify against him, and stated that she was too young to understand the implications of her statement, and this has left her feeling guilty for implicating her father in a crime he did not commit. I've considered the application and the affidavits filed by the parties and the oral evidence that was adduced for court, and this court finds that for determination is whether the petition satisfies the conditions set out under Article 50, Sub-Article 6 of the Constitution to warrant a new trial be ordered. Consequently, in the interest of justice and adherence to the constitutional principles, the court grants the petitioner's new request for a new trial, and the following orders do issue: that the conviction and sentence in Thika criminal case number 5165 of 2007, Nairobi High Court criminal appeal number 371 of 2008, and Nairobi criminal appeal Court of Appeal criminal appeal number 276 of 2011 are hereby quashed and set aside, and the matter is hereby remitted to the trial court for a new trial to be initiated based on the recanted evidence and any further evidence that the parties may deem necessary to present.
Mimi ni msichana wa Daniel Wanyeki, na nilishukuru sana wakati dada zangu wamekuwa wakubwa, wamejijua na wamesimama na ushahidi ya kusimama na baba yetu. Wameongea ukweli na wamesema baba yetu apewe haki yake, na hiyo ndio furaha yangu juu babangu atatoka, na tumefurahia sana. Mkubwa wakati baba alishikwa, babangu mkubwa ndiye alipigia shosho simu akamwambia vile baba yetu amefanya. Kutoka hapo baba yetu mkubwa ndio walitrain dadangu mkubwa kusema venye babangu amewafanyia. Sasa akapata hiyo uoga. Dadangu mkubwa mdogo ndiye alituma sister babangu afungwe. Wakati yenye baba alifungwa, watoto wakachukuliwa akaenda children's home. Kutoka hapo children's home ndio wakakuja wakijijua, nikawaendea, nikawapeleka kwa baba kamiti, wakaongea na baba akawaambia amewasamehea, na juu amewasamehe anataka waongee ukweli wao vile kuliendelea. Na vile walisema wataongea ukweli wao, Kirokondego aliwashika vizuri na wakamwambia kila kitu yoyote yenye iliendelea. Na kutoka hapo Kirokondego ameng'ang'ana, na ndio tumefika hapa tumefika. Juu hakuna mwenye ako na chuki na mwingine, nao watoto walikuwa wadogo wakiongea, so hawako wanajijua. na kwa saizi ni watu wakubwa na baba amewasamehea, ana uadui na mtu yoyote, anataka tu amani. Kwa sasa mimi nimemsamehea juu babangu alimsamehea. Lakini kama kuna kitu ameshika ya familia, juu wakati yenye tulitoka huko nyumbani, alibomoa nyumba yetu na mabati yakafence boma yake. Kitu sasa naweza omba ni babangu akitoka ampatie haki yake na kila mtu akae kivyake, na ndio babangu akuwe na amani na hatuna chuki na yeye juu baba yetu mkubwa.
Kwa tu ilikuwa ya saba. Ndugu yangu alikuwa anataka kuuza saba na Danieli Wanyeki alikuwa anakataa hiyo saba iuzwe. Sasa wakaaja maneno hapo. Ndio alikuwa anapigiwa simu ni ndugu yangu. Anaambiwa watoto wako wanaharibiwa ni Danieli Wanyeki. Nimeshukuru sana. Nimefurahia sana na nikaambia Mungu asante. Tumeenda muda mrefu sana.
This client of mine has been in prison for 17 years. 2 of those years were served in the remand. When he was convicted in 2000, I think it was 1 year, in 2008 he was convicted of the offense of incest of his 2 daughters aged 7 and 9. He had been charged of defiling 2 daughters, 7 and 9 as at that time in age. He was acquitted on the defilement of the eldest minor, that time 9 years, and convicted on the defilement, the count for defilement for the 7-year-old. And he appealed to the High Court and to the Court of Appeal. The sentence was enhanced on the second appeal at the Court of Appeal, and that was it. So when the new constitution was enacted, Article 50 sub Article 6 of the Constitution allowed him to approach court when new and compelling evidence had come forth. And in this case, that daughter he had been told he had defiled had come and retracted her evidence and said that it was evidence obtained from her by way of it was false evidence. She had been forced to say to tell lies to the court. And today the court has agreed with us that the man deserves a second opportunity in light of the new and compelling evidence to have the matter referred back to the lower court. Otherwise his conviction at the lower court, at the High Court and the Court of Appeal has been quashed and set aside. There has to be judicial processes administrative processes of releasing him. The DPP will now be called to make a decision whether he needs to sustain, whether there is evidence to charge. Is there evidence to sustain that charge of defilement after the complainant has said, well, that was a lie. And at the same time, and one of the issues that I had raised in court is that the P3, or rather the medical report, had indicated there were no lacerations or bruises. This was a 7-year-old and versus a 40-year-old. Definitely, this is one of those things that as a country, we look back and say, injustice served in the same temples of justice where justice is supposed to be served. In 2007, people had the zeal to implement the law, and circumstantial evidence, which is largely what the court relies on, is what was used to convict. I think that needs to be revealed. It needs to be looked so that we don't end up convicting innocent people. This is a man who has spent 17 years in jail. He has been absent in the better part of the childhood life of his children. His children even had to become street children. Okay. It's very unfortunate. Actually, the center of the dispute was some land that was owned by the father to my client, the petitioner, which was sold irregularly. In 2020, we filed that. In 2020, we got a judgment from Judge Mogo, and the land was that transaction was actually voided, and the land reverted back to the rightful owners.